Hello everyone, welcome to our channel as we embark on a compelling journey to unveil the lawsuits surrounding former President Donald Trump. In a break from over 2 centuries of American presidential history, a new chapter unfolds. Former President Donald Trump faces an unprecedented legal landscape, with 3 criminal cases already filed and a potential 4th looming. New York presents 34 felony charges related to hush money payments, while Florida adds 40 felony counts for alleged document hoarding and obstruction. In Washington, D.C., 4 felony charges stem from efforts to overturn the 2020 election, and in Georgia, investigations delve into potential 2020 election interference. Amidst these legal battles, 5 key questions emerge, shedding light on the lawsuits surrounding former President Trump, a prominent figure in the 2024 Republican nomination race. Join us as we navigate this intricate legal terrain, unraveling the complexities that define this significant moment in American legal and political history. Question 1. How many lawsuits has Donald Trump faced over 3 decades? In our exploration of the legal landscape surrounding former President Donald Trump, we delve into the staggering number of lawsuits he has encountered throughout his extensive career. A comprehensive analysis by USA Today reveals an astonishing tally of 4,095 lawsuits that have entangled Donald Trump, spanning a period of over 3 decades. This array of legal challenges encompasses an eclectic range of categories, reflecting the multifaceted nature of his business ventures and public engagements. A closer look at the breakdown reveals the diversity of these cases. 85 branding and trademark cases. 17 campaign cases. 1,863 casino cases. 208 contract dispute cases. 130 employment cases. 63 golf club cases. 190 government and taxes cases. 14 media or defamation cases. 206 other cases. 697 personal injury cases. 622 real estate cases. As we absorb these numbers, it becomes evident that the scope and complexity of these lawsuits are substantial. Notably, a substantial portion of these cases is tied to the business realm, offering a window into the intricate interplay of commerce and legal entanglements that have characterized Donald Trump's trajectory. For context, a comparative glance at former First Lady, U.S. Senator, and Secretary of State, Hillary Clinton, reveals a distinct contrast. While her legal involvement is significant, with over 900 lawsuits in her name, she primarily assumes the role of a defendant in these proceedings. These numbers may lead to a famous quote, "Behind every great fortune, there is a crime," by Honoré de Balzac. Question 2. What are the current criminal cases against Donald Trump? As we delve further into the legal landscape surrounding former President Donald Trump, our focus now shifts to the present moment, where he finds himself entangled in 3 criminal cases and 1 investigations. Criminal Case 1, January 6 and the aftermath of the 2020 election. This case, presided over by Special Counsel Jack Smith of the Department of Justice, unfolds within the confines of the U.S. District Court for the District of Columbia. During the tense interlude between Election Day in 2020 and January 6, 2021, a complex drama unfolded, as Donald Trump embarked on an extensive campaign aimed at undermining the legitimacy of Joe Biden's presidential victory. In this orchestrated effort, Trump and his advisors propagated falsehoods surrounding voter fraud, exerted pressure on Republican state officials to challenge outcomes in Biden-won states, concocted fictitious slates of electors, and exerted undue influence on Vice President Mike Pence, urging him to reject valid election results. The climax of this narrative materialized on January 6, as a fervent mob of Trump supporters breached the Capitol, interrupting the peaceful transfer of power, a hallmark of American democracy. Prosecutors, under the leadership of Special Counsel Jack Smith, have responded with a 4-count indictment against Donald Trump. The charges levied against him stem from his alleged machinations to disrupt the transition of authority. These charges carry potential penalties that underscore the gravity of the situation. Conspiracy to defraud the United States carries the prospect of a fine or imprisonment for up to 5 years. Obstructing an official proceeding carries a possible fine or a prison term of up to 2 decades. Conspiracy against rights could entail a fine, imprisonment for not more than 10 years, or a combination of both. Yet, the road ahead is fraught with intricate considerations, spanning logistics, security, and politics. The question looms: if charged and convicted, would Donald Trump face time behind bars, given the multifaceted dynamics at play? Moreover, the discourse takes a fascinating turn as we ponder the authority to pardon in this case. The charges laid against Trump are rooted in federal law, potentially affording him the power to pardon himself if he were to assume the presidency once more, although the legal validity of a self-pardon remains a matter of conjecture and debate. This criminal indictment may lead to a quote, "The great enemy of the truth is very often not the lie, deliberate, contrived, and dishonest, but the myth, persistent, persuasive, and unrealistic," by John F. Kennedy. Criminal Case 2, Classified Documents at Mar-a-Lago. This case, designated under the vigilant oversight of Special Counsel Jack Smith from the Department of Justice, unfolds within the jurisdiction of the U.S. District Court for the Southern District of Florida. In a gripping turn of events, federal prosecutors, spearheaded by Special Counsel Jack Smith, have placed Donald Trump under the glare of legal scrutiny. The crux of the allegation centers on Trump's alleged mishandling of highly sensitive national security documents during his exit from the White House in January 2021. These documents found an unconventional abode, scattered throughout his Mar-a-Lago resort, and prosecutors assert that Trump obstructed the government's persistent efforts to reclaim them. Startlingly, the accusation goes further. Trump reportedly revealed classified information to unauthorized individuals on multiple occasions. During one of those episodes, which was audio recorded, Trump allegedly displayed a top-secret military plan of attack while telling visitors, "As president I could have declassified it, but now I can't," adding that the document he was showing them was still a secret. The implications of this case reverberate profoundly. The potential penalties, as stipulated by law, are weighty. Counts under the Espionage Act carry a maximum sentence of 10 years each. Other counts, encompassing conspiracy, withholding or concealing documents, hold the potential for a maximum sentence of 20 years each. Counts linked to a scheme to conceal, false statements, and representations carry sentences of 5 years each. While these charges are undeniably grave, the broader context introduces intricate layers of consideration. The interplay of logistics, security concerns, and political dynamics casts a shadow of uncertainty over the possibility of a conventional prison sentence for a former president. The discourse on the authority to pardon takes center stage yet again. Given that the charges are rooted in federal jurisdiction, the potential for a self-pardon by Trump, should he be re-elected president, remains a topic of speculation, with the question of its legal validity continuing to loom. This criminal indictment may lead to a famous quote, "Our lives begin to end the day we become silent about things that matter," by Martin Luther King Jr. Criminal Case 3, Stormy Daniels' Hush Money. This case unfolds under the watchful eye of Manhattan District Attorney Alvin Bragg and is centered within the precincts of New York County. At the heart of this intricate narrative lies an accusation that echoes beyond its legal implications. Donald Trump stands accused of falsifying business records, embroiled in a scenario that traces back to a payoff involving Stormy Daniels, a notable adult film actress, who claimed a past intimate encounter with him. The contours of this allegation unfold against the backdrop of the 2016 presidential campaign, with the payoff serving as a calculated attempt to avert a potential sex scandal in the final weeks of the campaign. The story unravels further as we delve into the details. Michael Cohen, Trump's personal attorney and confidant at the time, orchestrated a payment of $130,000 to Daniels in October 2016, positioning the payment as a method to ensure her silence. Interestingly, Trump, during his tenure in the White House, proceeded to reimburse Cohen through a series of installment payments facilitated by his corporate entity. Prosecutors contend that Trump engaged in a complex charade, deliberately misrepresenting these payments as legitimate corporate legal expenses, thereby contravening New York law. The potential penalties that loom over this case come into focus. Each charge carries a maximum sentence of 4 years in prison. However, legal experts indicate that a scenario of probation rather than incarceration is a more likely outcome if Trump is convicted. The intricate legal nuances further suggest that a fine could be the probable consequence should a conviction materialize. The authority to pardon in this case takes an interesting turn, given the jurisdiction. As the charges emanate from a state-level crime, the power to grant a pardon rests solely with the governor of New York, adding a layer of complexity to the potential avenues of legal resolution. This criminal indictment may lead to a quote in a society governed by laws. Liberty cannot consist in the power of doing whatever we please, by Alexis de Tocqueville. Criminal case number 4, Georgia election interference. This case is under investigation. Our ongoing exploration of the intricate legal landscape surrounding former President Donald Trump brings us to a compelling criminal case that unfolds under the purview of Fulton County District Attorney Fani Willis in Georgia. This investigation delves into a crucial juncture in American democracy, where Donald Trump sought to overturn the outcome of the 2020 presidential election in the state of Georgia. Despite 2 recounts confirming President Joe Biden's narrow victory, Trump and his allies propagated unfounded claims of voter fraud, urging Georgia officials to reverse Biden's win and even devising plots to send fictitious electors to Washington. A particularly noteworthy incident emerged on January 2, 2021, when Trump engaged in a conversation with Georgia's Secretary of State, Brad Raffensperger, imploring him to find 11,780 votes in his favor. District Attorney Fani Willis spearheads the investigation into potential election meddling in this case. While the exact charges in this case remain uncertain until a grand jury decides to indict, a diverse range of potential penalties emerges. The possibility of racketeering charges, often utilized in organized crime cases, looms as one of the most serious. Conviction under this charge could result in penalties of up to 20 years in prison and a fine. Making false statements carries a potential penalty of 1 to 5 years in prison or a fine. First-degree criminal solicitation to commit election fraud, if proven, could lead to sentences ranging from 1 to 3 years in jail. As we navigate through this multifaceted investigation, the potential ramifications and the intricate legal dance surrounding these charges will remain subjects of keen interest and speculation. Considering the authority to pardon in this case, we find a noteworthy deviation from the federal jurisdiction. In Georgia, the power to grant pardons or other forms of clemency rests solely with the State Board of Pardons and Paroles, a 5-member panel appointed by the governor. Any potential criminal prosecution arising from this investigation would thus be governed by Georgia law. This criminal investigation may lead to a famous quote, "The truth is incontrovertible." Malice may attack it, ignorance may deride it, but in the end, there it is, by Winston Churchill. However, on the flip side, Trump has consistently labeled these prosecutions as political witch hunts. He positions himself as a martyr, claiming to be targeted by Democrats and the government on their behalf. Question 3. Could Trump's pending cases disqualify him from presidential running? The answer lies within the constitutional requirements for running for president, which demand 3 key qualifications: being a natural-born citizen, a U.S. resident for at least 14 years, and at least 35 years old. Beyond these prerequisites, American voters hold the power to decide the rest, regardless of whether a candidate has been accused or convicted of a crime. Indictment alone does not hinder someone from running for the presidency. As Professor Rosenstein, a law professor at the University of Minnesota, explains, an indictment signifies the initiation of a criminal process, not a declaration of guilt. Hence, Trump could potentially run for president even with ongoing criminal cases. While some civil rights organizations contend that Trump's involvement in the January 6, 2021 Capitol attack may have violated the 14th Amendment, which bars individuals engaged in insurrection or rebellion from holding office, the interpretation remains uncertain. The clause in question reads, "No person shall hold any office under the United States who shall have engaged in insurrection or rebellion." However, whether the events of January 6 qualify as insurrection or rebellion against the United States, and whether this clause explicitly prevents someone from becoming president, necessitate legal resolution in the courts. In essence, Trump's ability to run for the presidency is not intrinsically impeded by his pending cases. The ultimate decision lies with the voters, and only a conclusive legal determination regarding the 14th Amendment's application to January 6 events could potentially alter his eligibility for holding office. This answer may lead to another famous quote, "Law and order exist for the purpose of establishing justice, and when they fail in this purpose they become the dangerously structured dams that block the flow of social progress." Martin Luther King Jr. Question 4. Have other presidential candidates run under indictment? As we explore the unique legal landscape surrounding former President Donald Trump, we find that he is not the first presidential candidate to have faced criminal charges. Throughout American history, there have been instances of candidates running for the highest office while under indictment or even after convictions. One prominent example from the past is Eugene V. Debs, a socialist and labor leader who ran for president 5 times. In his 5th bid in 1920, Debs remarkably campaigned from prison after being convicted of sedition for protesting World War I. He defiantly campaigned as convict number 9653, garnering approximately 3.4% of the popular vote. In more recent history, we find former Texas Governor Rick Perry who sought the presidency while under indictment. Additionally, figures like the conspiracist Lyndon LaRouche and the colorful Tiger King star, Joe Exotic, launched presidential bids after facing convictions. These cases serve as intriguing examples of how the political landscape has witnessed presidential candidates navigating legal challenges while vying for the nation's highest office. Despite the legal burdens, some of these candidates managed to garner notable support from the electorate. As we delve further into the ever-evolving realm of American politics, these historical instances remind us that the pursuit of the presidency can be intertwined with complex legal dynamics, shaping the narratives and outcomes of presidential campaigns. This may lead to a quote, "Running for president from behind bars is not a setback, it's a testament to the power of the people's voice," by Eugene V. Debs. Question 5. Can Trump pardon himself for federal criminal cases? The issue of whether a sitting president can pardon themselves for federal criminal cases has been a subject of debate and legal scrutiny. The Constitution, in Article 2, Section 2, grants the president the power to grant pardons except in cases of impeachment. However, it does not explicitly address the question of self-pardons, leaving room for interpretation. In 1974, during the impeachment proceedings against President Richard Nixon, the Department of Justice, DOJ, issued a memo asserting that a president cannot self-pardon due to the principle that no one can be a judge in their own case. Nevertheless, this legal opinion has never been tested in practice. If Donald Trump were to win the White House in 2024, some experts suggest that he could attempt to pardon himself for any new federal charges shortly after inauguration. However, such an action would likely be contested and would probably end up before the Supreme Court for a definitive ruling. Notably, the current Supreme Court has a conservative majority due to appointments made during Trump's own presidency. It is essential to distinguish between federal and state-level crimes when considering the power of a presidential pardon. The Constitution restricts a president's pardon powers to offenses against the United States, which are typically federal offenses. State-level crimes, such as the charges Trump faces in New York related to hush money payments, are beyond the scope of a presidential pardon. In Georgia, where Trump faces an investigation concerning election fraud allegations, the potential for a self-pardon would depend on the specific charges brought by the district attorney and whether they involve multiple states or jurisdictions. Once a case crosses into federal territory, the possibility of a presidential pardon emerges. In conclusion, if Donald Trump were to win the presidency again, he could attempt to pardon himself for certain federal charges, but whether such a self-pardon would hold is uncertain and would ultimately hinge on a Supreme Court ruling. If Trump does not return to the White House, another president could potentially pardon him on federal charges, as suggested by some current competitors, such as DeSantis signals. As we continue our exploration of the intricate legal terrain surrounding Donald Trump and the power of presidential pardons, we remain attentive to the unfolding legal complexities that may shape the future of these cases. This may lead to a testing of a famous quote: "No person is above the law, and no person is below it, nor do we ask any person's permission when we ask him to obey it." Obedience to the law is demanded as a right, not asked as a favor, by Theodore Roosevelt, 26th President of the United States. In conclusion, our exploration of the legal landscape surrounding former President Donald Trump reveals a complex tapestry of criminal cases and potential implications for his political future. Trump faces a series of criminal cases, spanning federal and state jurisdictions, with charges ranging from hush money payments to allegations of election interference and classified document mishandling. While these legal challenges have significant implications, they do not automatically disqualify him from seeking the presidency in the future. The question of whether Trump can pardon himself for federal criminal cases remains unsettled, with constitutional ambiguity and historical legal opinions forming the backdrop. If Trump were to win the presidency again, attempting a self-pardon could lead to a decisive Supreme Court ruling. However, any pardon powers would not extend to state-level crimes, limiting their scope. Throughout American history, there have been instances of presidential candidates running under indictment or facing convictions, underscoring the intricate interplay of law and politics. Nevertheless, the final decision lies with the American voters, who hold the power to determine a candidate's eligibility for office. As we navigate through the legal complexities and political dynamics that define Trump's legal journey, we are reminded of the enduring significance of the justice system in shaping the nation's highest office. The unfolding legal drama surrounding Trump serves as a testament to the resilience of democratic principles and the weighty responsibility that rests on the shoulders of voters as they participate in shaping the course of American governance. If you enjoyed this video, please like, comment, share, and subscribe. Your support means a lot to us. Thank you.